versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No.
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm gonna make a motion for my.
Strap in, because this case is a full-speed collision between reality and sovereign citizen fantasy. Today we're watching Ashley Clark take the stand, or rather, take herself into legal disaster after firing her lawyer right as the hearing begins. And mind you, this wasn't some complicated, high-stakes federal trial. This was a straightforward probation violation hearing with a deal already on the table. Her attorney had everything lined up, an agreement, a stipulation, all she had to do was say yes. Instead, Ashley decides today's the day she becomes her own legal advocate. A bold choice for someone facing drug violations, missed check-ins, skipped treatment, and a brand new arrest. But Ashley isn't just dismissing her lawyer, she's stepping into the courtroom with the confidence of someone who watched 3 sovereign citizen TikToks and believes she's found the legal cheat code. We've got drama, delusion, denial, and a judge who's seen this movie one too many times. And trust me, this thing escalates fast. From questionable legal theories to complete courtroom self-destruction, this hearing becomes a textbook example of why representing yourself is usually the worst idea imaginable. Let's dive in, because Ashley is about to turn a routine hearing into a judicial train wreck in record time.
All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want to contest the hearing?
I'm gonna contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right, Ms. Clark.
And here it is, the exact moment everything derails. Ashley firing her attorney isn't just impulsive, it's catastrophic. The judge goes into full caution mode, reminding her of the rules, the procedures, and the expectations she's now responsible for. This isn't TV court where you get to monologue your way out of trouble. This is a real courtroom with real consequences. The judge is practically begging her to reconsider by reminding her she must follow the same standards as an attorney. But Ashley? She's locked into self-representation like it's a personality trait. What's wild is she's doing this during a probation violation hearing, a type of hearing where the burden of proof is much lower than a criminal trial. Meaning, the state barely has to work to prove she messed up. A lawyer could have mitigated the damage, negotiated a sanction, maybe even avoided jail. Instead, she's stepping into the ring bare-knuckled, blindfolded, and swinging it goes.
Will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
Now here comes the part where sovereign citizens usually imagine they'll expose some courtroom conspiracy, but in reality, the prosecutor is simply calling the probation officer. And this officer doesn't come empty-handed, he's bringing facts, dates, documents, and direct admissions. Everything the court needs to find a violation. The contrast here is incredible. On one side, you've got the state walking in with organized evidence and a trained witness. On the other, Ashley, who just fired the only legally trained person fighting for her, and now has to cross-examine the very officer who supervised her probation. This is where most sovereign citizens freeze, because the script they memorized online doesn't teach how to challenge real evidence. Spoiler, she doesn't even try.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions?
This testimony is a brick wall for Ashley. The probation officer confirms the positive meth test, the signed admission, the failure to report, and her new arrest. It's not just one violation, it's a pileup. And yet, Ashley's strategy is to say there's no evidence. That's like hearing a fire alarm, seeing smoke, feeling heat, and saying, there's no fire unless fire itself comes and testifies. Her refusal to cross-examine or offer evidence isn't confidence, it's surrender dressed as defiance. She had the chance to challenge specifics, explain circumstances, or show effort at compliance. Instead, she leans on vague sovereign jargon about jurisdiction. In court, that's the equivalent of answering a math test with interpretive dance.
You have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now, I see no evidence. This has the needed personal subject matter
Argument, I'm asking
jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Morsinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
It's the moment where most defendants at least attempt a closing argument rooted in reality, something like acknowledging mistakes, explaining setbacks, offering mitigation. Judges appreciate responsibility. But Ashley? She chooses sovereign pseudo-legal word soup over strategy. The prosecution lays out a clean, methodical case showing repeated violations and total non-compliance. They emphasize the nature of her original charge, endangering a child, and the seriousness of her continued drug use. It's a strong, logical closing. Meanwhile, Ashley now has one last chance to salvage even a sliver of leniency. But instead of addressing drug use, missed appointments, or new arrests, she's about to dive headfirst into sovereign mythology.
That has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be.
And here we go, Ashley unleashes the full sovereign citizen playbook. She claims the state is a fictitious plaintiff, that there's no injured party, and that the court lacks jurisdiction. None of this addresses reality. Probation isn't about an injured human witness, it's about compliance with court-ordered conditions. Her entire argument is built around internet
My findings, the state's shown by preponderance of the evidence that you violated probation in this case, using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke